Perfect. Of information, and for me personally, when I went home, I slept well. You know, my brain was still going, but I managed to sleep. Today we're gonna have almost the same thing. Yesterday we touched a lot on the youth, the role of our youth, and then we talked about our own health as well. Today we're gonna talk more about health. And when we were talking about health yesterday, a lot of stuff came up, and especially around the justice system. Now we're gonna probably continue from there, and if you do have a lot of questions regarding justice system and the unfairness of the system towards us, the African community, and you know, this is our chance, especially when it comes to our youth. We do see a lot of our youth ending up in the justice system, and sometimes it's out of our own fault, or sometimes it's not. And so we do need to equip ourselves with some knowledge when it comes to the justice system and when it comes to protecting ourselves and our youth. We do acknowledge, like for me personally, one of my cousins actually, he is 17, and he got stopped because of the color of his skin, and he was driving a BMW that was registered to his sister. And that, I think it was unfair treatment, and we didn't know really what our role was to be able to, and our rights, to be able to mitigate some of the things that went around there. So I think today we're very fortunate to have somebody who is going to talk to us about justice system when it comes to youth, and I think it is high time that we take notes and really pay attention. Because each and every one of us here knows somebody who have a child who will be unfairly treated by the justice system, and who might or might not get involved with the justice system. So I think we need to pay attention, and we need to question what are our rights when it comes to that. And for our next speaker, I'm gonna let Vicky introduce our next speaker, and she will be the moderator for the session.
Thank you, Achara, for speaking about justice and how our youth and us Africans sometimes encounter those injustice treatment. I just want to echo again that a lot of the presenters that are coming to speak to us have put a lot of work into this presentation, and the fact that we may speak in the background and be destructive and things like that, it really distracts the person that is speaking up here. So I urge you all to be considerate, because if you took the time to come from home and be a part of this conference, we should be eager to learn, because knowledge is power. Today with us, we do have Miss Lisa de Gara. I will speak a little bit to her biography. She's a manager of a small centers with Action for Health Communities, leading the program since 2021, my apologies. Her team delivers the settlement workers in school programs, supporting newcomers' success from kindergarten to grade 12 throughout Alberta. In 2023, she completed her Master's of Science in Education. So she's not only coming to speak to us, but coming with a lot of experience, and a lot of experience with us, immigrants. And I think she will be bringing awareness, knowledge, and food for all of us, food for thought for all of us to partake in it. Without further ado, Lisa, you're welcome. Thank you.
Thank you very much for the introduction, and thank you to everyone for having me here today. I appreciate the chance to be here. My boss, my manager, Susanna Domo, invited me to be here today, and I appreciate the chance to talk about this subject, to give some of the information that I've had the chance to learn over the last several years. I have a couple of paper handouts as well that I'll talk about in a moment. But again, thank you very much for having me. Thank you for lunch, it was lovely. And I'll spend a little bit of time now talking about legal and social support services, specifically focusing on youth, with time for some questions afterwards. So thank you very much. So, see if it works. I got my fingers crossed. Next slide, does it go? We will find out if it'll work. If it doesn't work, I'm going to do a bit of, I might very kindly ask if you'd be willing, thank you. Next slide, please. Excellent. Okay, so essentially a couple of the things that we'll talk about today. Very quick introduction of myself and what I system for youth that are 12 to 17 here in Canada. They can get access to different supports and different resources. We'll talk about the Charter of Rights and Freedoms that we have here in Canada, which is essential. I think we had some discussion about unfairness within the system here in Canada, and that absolutely exists in practice. There are awful mistreatments of people that we witness on the basis of racism, on the basis of xenophobia. But fortunately, we do have legal ways of challenging those unfairnesses, and one of the ways that we have that is the Charter. We'll talk about resources for youth, aged 12 to 17, and then resources that exist for adults. And then, of course, time for questions. Next slide, please. Let's see if I can get it working. But oh, no, it went the wrong way. So 2, please. And then 1 more. Thank you. So a very important disclaimer to all of this. I am not a lawyer. My younger sister is a lawyer, but she was not invited to be here today. I was. So as a result, I don't want to speak about any kind of specific legal case. I can speak about sort of systems of law generally, and we do have some referrals at the end for resources that can be accessed, for lawyers that can be accessed, for legal supports and legal systems. So while I cannot answer questions about specific cases today, I can hopefully point people in the right direction if there are specific questions that they have. Next slide, please. Okay, so here in Canada, we have essentially 2 systems of law. We have, the first system of law is civil. Civil law is basically about managing disputes, managing arguments between people. If you had a boss who said you were going to be paid $25 an hour and you get your paycheck and you're only being paid $22 an hour, that's a civil law dispute about contracts. If you slip on the sidewalk outside of someone's home because they did not shovel the snow and you hurt yourself, that could also be a civil case. That's an injury-related case. Most things in civil law are about money, property, contracts. Sometimes this can have an impact with youth, especially if we're thinking about property damage. The classic story, we have some children, they're playing outside, a ball gets kicked and smashes through a neighbor's window. That's usually just a civil issue, the cost of repairing the window, fairly straightforward. And in the simplest terms, criminal law in Canada is about anything that causes or is perceived to cause harm to people or to society. So any type of violence is considered to be a criminal law issue. Drug-related offenses are considered to be a criminal law issue. Theft, obviously a criminal law issue. And sometimes behaviors which either could hurt people or have hurt people. So an example might be if somebody has a lot of alcohol to drink and they get behind the wheel of a car, even if they don't hurt anyone, oh sorry, see if it'll work. Okay, it should be on, thank you. Even if they don't hurt anybody after having drunk alcohol and driven the car, maybe that becomes an issue of they could have hurt somebody. So criminal law in Canada, okay, perfect. Excellent, thank you, Suzanne. So fortunate to have her as my boss. Thank you very much. And so this becomes, essentially, I was going to do all that, perfect. Criminal law is about causing harm. Either harm that has actually been caused or harm that could have been caused. So often with drugs, it's about harm that could have been caused. If it's about driving offenses, harm that could have been caused or harm that was caused, basically. Related to this, and I have a couple of copies that I'll be able to share with people if they're interested. Here in Canada, we have an essential founding document that is the Charter of Rights and Freedoms. It's quite elegantly presented. It's like a one-page document. Like I said, I have some available to hand out if people are interested. But essentially, the Charter of Rights and Freedoms outlines all the rights and all the freedoms of every person who is in Canada, irrespective of age, race, national origin, disability, and language status, all manners of different for people here in Canada. Many of the charter categories, sections, are specifically about rights within the justice system. So there are rights, for example, about the right to education. There are rights about language. There are rights about freedom of movement, equal protection under the law. But many of the sections of the Charter specifically are about justice and how people are treated when they have exposure to the justice system in any kind of way. So this is, the font is very small, don't worry, like I said, if you'd like one, I have some that I've printed out. But the really important detail here is that this document that has absolutely every single right that people in Canada enjoy, everything contained within the red square has to do with the rights in the justice system. And importantly, of course, we can have many experiences in the justice system that are unfair, that are racially biased, that are prejudicial. But in terms of the interpretation of the rights, here in Canada, it's quite absolute. You have sections 7 to 14 in the Charter that outline exactly what those rights are. The first one, if anyone is arrested for any reason or stopped, as was mentioned in the story, any person who is arrested has a right to be informed of why they have been stopped, why they have been arrested. If there is a charge, what that charge is. This is a universal charter right. It cannot be exempted. Nobody can say, oh, well, I'll tell you later. Oh, you're 16, you don't need to know that right now. Why are you asking those kinds of questions? Everyone has the right to know why, and if there's any kind of a challenge in that respect. Every single person has the right to a lawyer. I'll talk a little bit about access to lawyers in a moment, but the important detail is that because every person has a right to a lawyer, if a family or if a person cannot afford a lawyer, they can get access to one for free or for low cost. This is a universal right that we have under our system. One of the most important ones, and this is one that is critical and key and essential, is the right to be presumed innocent until proven guilty on any charge for any reason. We have in Canada this presumption of innocence until proven guilty beyond a reasonable doubt. So that means in all cases, there has to be so much more evidence that demonstrates that the person is altogether guilty before they can be considered to be guilty. And again, oftentimes there are systems, especially jury trials, that can be prejudiced, that can be racist. But as a right, this is uniform and universal. The right to a free and fair trial in a reasonable amount of time. Now, anybody here who has lived in Canada for a while knows things don't happen very quickly here. Everything in Canada takes way too long. And so we actually have rules that specifically say that if a trial can't happen in a specific period of time, they just throw the whole thing out. It's quite controversial actually, but we have the right to have a trial in a reasonable amount of time. How we define reasonable can vary a little bit, but it basically means these are not things that are allowed to stretch on for years. They have to happen in a reasonable period. Protection against cruel and unusual punishment, a lot of ways that that can be defined, but basically if somebody is held in the justice system for any reason, for any amount of time, that they are protected against torture, against violence, against deprivation of food and water, that all of these things are universal. And finally, we have two protections from self-incrimination. Nobody can be forced to say anything in a court that would make them appear to be guilty if they don't want to disclose it. They have the right to remain silent. And the final one, which I know is so essential in working with newcomers, in working with people from around the world, is the right to an interpreter. In this country, in part because we have a constitution that assures rights in English and in French, a right is built into the Constitution of Canada that anyone who needs to appear in court for any reason has a right to someone who can support them who speaks their language, whatever language that happens to be. Sometimes it can be challenging to find interpreters, sometimes the timeliness of the interpreters can be an issue, but every single person has the right to have those services delivered to them in the language that they best understand. I have had clients for whom this has been a challenge. I had a client who was needing to appear in court in Wetaskiwin who spoke Amharic. And the court coordinator told me, we don't have anybody who speaks Amharic. And I said, I don't care. It's the law. It's their right under the Constitution. You have to find someone. And so this is something that can also be challenging, making sure that people have what they need in order to be successful, effective, to speak their case. But in terms of language, everyone has a universal right to receive justice, access to justice in whatever language they are most comfortable speaking. So, that's the charter. My sister, I'm sure, would be quite upset because she'd say, you have to talk about all the other parts of the charter, it's very, very important. I said, it is what it is. People have got other things they got to talk about today. But one of the other really important details to note here in Canada is that we have two justice systems, one for adults and one for youth, and they work slightly differently depending on the age of the person. If you are 18 years of age and older in Canada, you are considered to be a full adult. I'll talk about that in a moment, but it doesn't matter if you are 18 years and 1 day old or 101 years old, you have the same system of justice. But for youth who are aged between 12 and 17, they have access to a separate system of justice, which is called the Youth Criminal Justice Act. If there's a youth who has challenges in the justice system who's 11 or younger, they are considered to be not responsible for their actions in Canada because they're a child, they're too small. There can be some exceptions, but basically if you are 11 years old or smaller, there's a completely different set of rules for you because you're a child. But if you are between 12 and 17, there's an acknowledgement that these are youth, these are young people. They shouldn't be treated as adults because they're young, they're teenagers. There's an acknowledgement that as a teenager, maybe you make a mistake. Maybe something isn't exactly considered the way that it would be for an adult. And so the youth justice system basically says if young people do something that isn't legal, that they should be held accountable, but in a way that still acknowledges that they are children. So how does that work? We'll talk a little bit about it. I wanted to give some examples about how the type of precise language can have really important impacts. So in this example, we're going to say that there's a person called Lisa, which is my name, and in this case we have Lisa is 16 years old, eligible for the Youth Justice Act. So the first one we have breaking the law, and in the widest terms, it is doing something that is against the law, whether you were caught or not. Doesn't matter if you were caught or not. So if 16-year-old Lisa takes a computer from the store, she is breaking the law because she has committed theft, even if nobody saw. We have, if Lisa, in this scenario, took the computer from the store and ran, and is spotted with Lisa. Okay, sorry about that. Then she could be charged with theft. So being witnessed, having a violation of the law witnessed by an officer is then the charge. And then finally, there's this idea of being alleged. If a police officer sees someone doing what they believe to be breaking the law, but it hasn't yet come before a trial, that is alleged to have stolen. So in this case, taking the computer from the store, breaking the law, being charged with theft, and now that you've been charged, in this case Lisa must appear in court, she is alleged to have committed theft. Now these three terms are important because they determine how the other provisions and services are available, especially to a young person. So, for young people who are 12, 17 years of age, because they're young people, they have access to this Youth Criminal Justice Act, YCJA, extrajudicial measures. And that basically means, extrajudicial means outside of the court system. So acknowledging that a young person is a young person, acknowledging that it might not be appropriate to think of them as an adult. They have opportunities to have different supports and services that they can access here in Canada. One of them is essentially you can have a warning, get a written warning or a written caution. But most often we see young people getting referrals to alternative programs. And there are a couple of different main alternative programs. One of the common ones is addictions counseling. So if we have a young person who has been struggling with alcohol or drugs, and that might have been the reason why there has been a criminal activity that has happened, those programs will be offered through these alternative programs for free, with the intention of helping that young person to manage the addictions that might have caused that in the first place. There's also a really important component which is called restorative justice. Restorative justice you might have heard about in a lot of different circles, but essentially it means providing the young person the opportunity to make right where things have maybe not gone exactly to plan, sort of a formal way of restoring and returning the community to a sense of justice. And there's also community service, which might be doing work in the community that is maybe not so fun or not so interesting, but in service of continuing to improve the community. So we'll return to my, If we have an instance where a police officer encounters a young person aged 12 to 17 and decides to refer them into this extrajudicial measures program, they have a choice. Would they like to participate in the extrajudicial measures, which might involve going to a community program, which might involve doing that restorative justice work, or going to court? The youth always have the choice. They don't have to choose to do addictions counseling or community service if they don't want. They can take either of the pathways. If they do choose extrajudicial measures, and I'll talk about what they can look like specifically, then it's absolutely legally mandatory. So in this case, we have a second system, an additional system, but it is as mandatory as the court system itself. Oftentimes, those youth are supported by people in the community. In some cases, it might be a probation officer, but with a lot of the youth that I have worked with through the system, there is a organization called a Youth Justice Committee. There's usually one in each town or city or community, so I worked a little bit with the Camrose Youth Justice Committee. I worked a little bit with the Edmonton Youth Justice Committee, and usually that's a group of between 6 and 8 adults from the community. They are not police officers, they're not lawyers, they're just everyday people. Very often they're parents from the community, sometimes they're teachers, maybe some people who are just retired who want to be members of the community. And they gather together with the young person and their parents and talk about how they can work together to help that young person engage in restorative justice and ultimately make sure that that young person feels that they're on the right kind of a path. The youth justice committees help the young people to support those extrajudicial measures. So if you have to do community service, maybe you have the 4 hours of community service every Wednesday night, and then on Thursday afternoon you're going to the youth justice committee to talk to them about what that has looked like. Youth justice committees really welcome the participation from parents, from family members, from community members. They really want to make sure that young people are supported by a whole group of people as they go through this process. If the youth successfully complete their program with the Youth Justice Committee, with those resources, then it's done. There's no further record, there's no further engagement. They engage with the community entity, and then it's done, basically. So I wanted to give an example of what this might look like in practice. So let's return to Lisa, that's me. In this case, stealing the computer age 16. In this case, because they wanted it to be restorative justice, Lisa would have to go to an old people's home and teach the old people how to use computers on the weekends, and would also have to apologize to the owner of the computer store. So that's real restorative justice, apologizing to the person who was harmed, and also demonstrating a willingness to be helping in the community. Unfortunately, in this case, Lisa did not take it seriously. It did not go great. So she shows up late for her first day of community service. She tells the computer store owner, grow up, get better security cameras, and ultimately does not turn up for any of the things she was scheduled for. In this case, she's not successful in her extrajudicial measures, and because she didn't take it seriously, now the opportunity is gone, and she has to go through the regular court system. Now, this is very challenging because oftentimes the extrajudicial measures they look different. They sometimes don't look and feel as serious as dealing with courts, dealing with these very escalated things. But ultimately, they're just as important because they're about that young person being willing to show that they're making the efforts to engage in that restorative justice. So in this case, unfortunately, Lisa did not take it seriously, and she's going to have to go to court. But what about the better version of events? So in this case, she has to go to do her community service with the seniors, teach them how to use computers, has to apologize. So she shows up, she arrives on time, 8 a.m., Saturday and Sunday, for all 10 days of community service, 5 weekends, it's a lot of work. Teaches those seniors how to use computers kindly, thoughtfully. She writes the letter to apologize to the computer store owner and says she is sincerely sorry. She's completed her measures, and it's done. No further need to go to court, no further engagement. The process is complete. Now, that example intentionally is quite simple, but oftentimes those measures will look that way. Something that has specifically to do with what happened and how that young person can be given a chance to try to do things a different way. Now, that's the case for youth, and obviously we'll have time to take questions. We have a separate system as soon as a person turns 18. So a 17-year-old person might have access to a system like that. 18, 19, everything older would engage through the conventional court system. Any adult who is charged with a crime must appear in court. Even if they're able to get access to alternative measures, this is necessary, it's mandatory, it's compulsory. This is one of the biggest differences. I did want to flag this very fleetingly because enough of the times in Action to Help the Communities, the organization where I work, the clients that I've worked with, oftentimes this is a terrifying thing. It's very intense, it's deeply upsetting, it's stressful. There's all this kind of language that's not used in any other context, and yet the most important thing in all of these contexts is to seek out specific help of somebody who really can offer that assistance. And most often that means getting a hold of a lawyer as soon as there's any kind of problem, any kind of concern. One of the families that I had spoken to, there was a person who needed legal help. And someone else in their family said, I don't think I should help them. They got themselves into this mess, they can get themselves out. I don't see why I should have to make such an effort to help them. Obviously they're entitled to that opinion. In my opinion, any instance where we have a family member, a community member, and so on, who's in need of that kind of support, this can make the difference between an outcome of somebody maybe being able to access alternative justice, maybe walking home at the end of the day, or having a much more serious legal consequence. So lawyers, it's intimidating, it's challenging, it's a pain, but it's one of the most essential components of ensuring that people get access to the justice that they deserve. So do not delay, don't wait. If there's a document that arrives that says court is in 60 days, don't wait till day 58 to seek out a lawyer. That's the immediate thing, immediate. We have had a lot of clients who come in with, yeah, I got this notice in the mail and it was about 2-3 months ago, and I'm having a full heart attack. So as soon as there's a concern, because that allows for the ability to access those alternative measures, access additional supports, and in most cases, help to get to a better outcome for that person, for that family. They are available for free. Lawyers are available for free for people who cannot afford them. And if they need to have an income scale version, so basically a lower cost lawyer, that's also available. Interestingly, here in Canada, we don't have public defenders like they do in the United States. So you might have seen on television, public defenders, people whose only job is defending people for low cost. In Canada, it doesn't work that way. We have most people who are lawyers in other fields basically all the time and do a percentage of their time in these legal aid support roles. So they may have a lot of very varied experience, and this is most often people who really want to be supporting the community. So most often these are lawyers who are a great support and who are really helpful and who care a great deal. Obviously some of them are not so good, but mostly they're very good. There's always a lawyer at the courthouse who's called duty counsel. Duty counsel is at the courthouse to help answer people's questions, to help through any kind of support that they need. They're really helpful as well. I don't recommend waiting for duty counsel though, especially if the legal system is new, especially if people are more comfortable in another language, especially if they want a bit more context. Because duty counsel is great, but you basically just call them up and they've never met you before. Versus a lawyer who's assigned to you, who gets to know you, who takes the time to meet with you, who takes the time to understand about you, about your circumstances, about your family. As I mentioned, you always have the right to an interpreter, any language, anywhere in Canada. Finding an interpreter is often complicated. It can be quite lengthy. They have court-assigned interpreters, but they are highly effective. So getting a little bit more time is also very, very helpful to making this as successful as possible. They can help arrange the interpreter. Organizations like Action to Help the Communities can also help with that kind of support. Ultimately, we all want to make sure that people can speak in their defense, that they can explain, that they can provide the context and the information that helps the court to understand about their circumstance. And this is a fundamental right. So we want to make sure that that's always available, universally available. It can be a little bit challenging, but you always have the right. And if the court coordinator says we don't have anybody who speaks that language, we'll make sure you have my email and I can yell at them. I've done that quite a bit. So, we talked about the youth alternative programs. There are a few diversion programs available for adults. Not as many, but there are a few. If there is someone who has a first-time charge for something minor, usually for anything non-violent, they may be eligible for some kind of a diversion program. Often these are addictions counseling, community service, again, a focus on restorative justice. And the idea is that they want to stop this, to have this person stop the cycle and be able to have a different kind of path. Usually they have to have been charged with something non-violent, and it is on a case-by-case basis. So this is another example of where having a lawyer early on is a really important asset, because the lawyer may be able to advocate for these diversion programs, for these alternative solutions that are available. Ultimately, all of this concerns a very, very specific part of the justice system, which is when there has been an allegation made, when there has been a specific incident. But we know in community that the community's engagement begins far earlier than that and continues far after that. Most often, formally, this is called recidivism. They want to reduce the likelihood that somebody who has been charged with a crime is charged with another crime afterwards. And this is one where the community is probably the single best asset that is available to helping young people, to helping people of all ages. And some of the things that we know that can be really effective are like cultural programming, education-specific programming, addiction support, employment support, housing programs, all these kinds of social supports that can help someone to continue to be part of their community and get the kind of supports that they need in order to be successful on an ongoing basis. So the job says, education's a great idea, not sure if it's our issue. But that is one where the community has the greatest capacity and the greatest potential to be effective in supporting people, young or older, in being able to be effective. I will make sure that we have this emailed and available to everyone so that you'll have these resources available. But a couple of resources that are really helpful. The youth justice committees, as I mentioned, are those committees of adults within a community who really want to support youth and to support their families in being able to build forward towards community justice. There are ones in every different community here in Alberta. Across Canada, there are also youth justice committees, and models exist similarly in many other countries. There's a wonderful organization called the Office of the Child and Youth Advocate. If a young person in your family, in your community needs support, this is one of the very first places that I would reach out. They have a specific mandate to support young people who are engaged with the justice system, also young people who are involved with foster care and a number of other community support entities. I have worked with a lot of members of the Office of the Child and Youth Advocate personally. They are incredibly effective, and all they do is support young people who are vulnerable and who have additional needs. So I would highly recommend the Office of the Child and Youth Advocate here in Alberta. They do phenomenal work. I've been very impressed supporting them. There's also information about restorative justice. How does it work? Where is it available? What can it look like? It can look like a lot of different things, but it's typically highly effective in community support. I also have a resource that's just specifically about Youth Criminal Justice Act and how it's different from adult criminal code here in Canada. There are a couple of important differences. The website does a really good job of outlining them. In terms of resources for adults, again, youth can also use these resources, but they're really helpful. Legal aid, those are the lawyers who are able to support either for free or for low cost when people need them. You can also speak to duty counsel, the person who's at the courthouse every day, up to 14 days beforehand if you call at the telephone number. Again, they're also really helpful. They are often quite overworked though, so it's better to plan further in advance. I put the link to the Alberta Court Interpreters Association. These are individuals who are certified as having the language level and knowledge level to be able to interpret in a court context. So obviously, in a pinch, anybody could provide support in court, but it's often helpful to have someone who not only has the language skill, but also the knowledge of the legal system so that it can really be extremely effective and very accurate. There are also a couple of other resources about supporting people who have been involved in the justice system, whether they have been involved and are no longer involved in the justice system. Maybe we have community members who want to be supporting young people. Several of these organizations have done some really, really effective work. And then the final one, the framework, just has some information about generally supporting people within the justice system and community members. How can we ensure that people are well supported and ultimately that communities are well supported as well? So, I think that's it. So, thank you very much for listening. I appreciate it. And we have some time for questions. I'll also get my handout, so if people want to take home some papers, I have them. But I certainly have time for questions. How do we want to run the microphones? Perfect.
Okay, I have a question right here.
Thank you very much for the wonderful presentation, and to make it clear about the legal laws here in Canada, which is very informative. Thank you. My question is regarding the charges, like a case for minors, like between from 12 to 17. If it's one in that age, if a kid commits a crime, like a shooting someone with a gun, what charges will be laid upon that kid? Number two, if the kid is from between 12 below to between 12 and 8, if the kid also like commits a crime like shooting someone with a gun, thank God in Canada people are not accessible to guns like in the US. But should it happen, what kind of charges will be against that kid? Will it be criminal law, capital punishment, life imprisonment? What charges will be laid upon that minor?
So excellent question. So in the case of a young person aged 12 to 17 who has done an act of violence, so gun violence or assault or any other kind of violence, they may not be able to access the alternative justice program, but they would access a justice system that is specifically for young people. So we have youth facilities where young offenders, who especially have done violent crimes, are able to be held. It's similar to a prison, but it's not exactly a prison, because the children who are in there still attend school every day, and they also have access to community programs, with the idea being that when they're done there for several years, that they can be released back into the community. Younger people's sentences are not as long as adults. They're typically fewer than 5 years, except in very, very unusual cases. And as mentioned, the kids that are in the facilities attend school every day and have access to supports and so on. In the case of a child who is younger than 12, so 11 years old and younger, most often in that case, because the child can't be responsible for their actions because they're too small, most often they would be removed from their family environment because there would be concerns that the child is not safe where they are with this intensity of violence from such a small age. So most often the child would be in an alternative housing context and getting that kind of support. You also asked a very good question, what is the punishment in prison, capital punishment? In Canada, capital punishment has been illegal since the 1970s, so we don't have any kind of death penalty or similar penalty. People can have lifetime in prison, but that's the harshest sentence that's possible. So thank you very much for your question.
My question again on the youth. How many times can a youth actually access the alternative or the struggle of justice if they are a repeated offender?
It's a really good question. I think in most cases, it's one, sometimes two. Like sometimes there will be a willingness to provide that access to an additional youth justice, like Alternative Measures Act. Probably twice. By the third time, I think that there would be kind of a referral up to say that maybe these alternative measures actually haven't been as effective as we hoped. We had hoped that this would have different outcomes for this young person. They're not yet having those outcomes. But one of the other things that can be done is that if a young person gets access to alternative measures a second time, probably that would be a different type of conversation, saying maybe this wasn't the right set of alternative measures for this young person. Maybe they need a different kind of support, maybe more strongly enforced school support, things like that. So one, usually two, but by the second time around, there would be some pretty serious questions about maybe we didn't get it right the first time with what that young person needs to be successful, to be effective, and ultimately for the program to be effective. So thank you for your question.
Again, thank you for a great presentation. The thing that I would like to know, normally in the United States, when young offenders did some mistakes, they go after the parents. I don't know if that's the case with Canada.
I would say typically, thank you for your question. I would say typically no. Most often, again, if we have young people who are very small, who are younger than 12 years old, it would typically be a child protection issue. So in those cases, they might be asking questions about the family, about where that child is living. For young offenders who are like 12 to 17 years old here in Canada, mostly they want for the family to be involved in the justice process, because we know that if the family feels involved, feels included, and feels listened to, then the child is ultimately much more likely to be successful. And they're much more likely to have the justice program be effective. So oftentimes it's essential actually for parents to be involved in the alternative justice measures and in the Youth Justice Act so that the young people and the parents or other family members can work together and have some success. But ultimately, I would say the parents are very unlikely to have any kind of punishment or anything like that. Mostly it's just that it's very important for the family to be involved so that that young person can be effective. So they might have to come to the Youth Justice Committee meetings, for example, or Youth Justice Committee might ask to speak with the parents or to understand the context of what's going on with the parents. Maybe there are other kinds of supports that the family could benefit from that could also help the young person benefit. So I would say here in Alberta, the idea is that it's a little bit more understanding the need of the family so that the young person and the family can be successful altogether. Thanks very much.
Thank you for the presentation. I'm from Red Deer, by the way.
Oh, fantastic.
In Red Deer, we work very closely with the Youth Justice Committee, and we have prevented many youth age group from 12 to 17 from being charged and indicted. I'm just wondering, because crime sometimes connected to some aspect of cultural connotation. As an immigrant, I'm just wondering, what is the component of the youth of the committee? Are they unicultural or multicultural individuals in that committee? Thank you.
Excellent. Thank you very much. It's an excellent question, and the honest truth is, youth justice committees at the moment, they're volunteers, and I had the opportunity to speak to all of the youth justice committees in Alberta, I think it was in May, and overwhelmingly, the youth justice committees are white Canadian volunteers. They're overwhelmingly white Canadian, non-immigrant, English-speaking volunteers who serve on those committees. And part of the reason why I was approached to provide some training for them was exactly what you described. Do people have a good understanding of culture, of how culture can impact people's perceptions of the world, how they understand the world, and how that can ultimately impact the youth's success? So I would say at the moment the youth justice committees are too white. They're not diverse enough. This might be an opportunity for people who, if they feel that they have the time or that they have the capacity to consider participating in the youth justice committees. I think it can have a really, really meaningful impact on the success of those committees to have someone who comes from a comparable cultural background to the youth, or even just a newcomer cultural background, to say, maybe there's been a different perception, maybe there's been a misunderstanding, maybe there's a different way for us to view this. So I would say the youth justice committees are trying to build their cultural competency. I would not say that they're incredibly effective at this moment. I would say they're getting better, but they're still working on it. And I think that the youth justice committees would be at their most effective if there were more people from different communities who are able to participate in those youth justice committees in service of justice really for all youth. So thank you very much for that question. And I work in rural Alberta, so thank you for working in Red Deer. Appreciate it.
Ask the question, then I have one last question centered on that.
Very informative, thank you. So how does an officer determine if really the young offender needs extradition, something, and assuming that they missed it, does the court throw it back? Now that's one question. The second question is have the justice system thought about reaching out to organized communities for the same, like this group of privileged, like white people who are sitting next to me?
Could you repeat the second question?
The second question is, the organized communities, the organized communities like our community, has the justice system thought about reaching out to our community about what could be a possibility if a young person from my own community offended or did something?
Excellent. So thank you very much for both the questions. So I'll answer the second question first. I think that a lot of the youth justice committees would love for cultural organizations, for community organizations to have a bigger role in this process. I think it's a little bit of they don't know what they don't know. They don't have very good exposure to a lot of community organizations, especially ethnocultural organizations. And that's something that I've been kind of poking them a little bit on and hoping to build some more capacity in. One of the things where I think that can be effective is, and maybe something where an organization like the one I work for can potentially offer some support, is making sure that information about those committees is circulated in rooms like this one, but also to organizations like Alberta Justice, so that they have an understanding of there are community members who would like to be a part of this process, and how can we work to ensure that we bridge that gap and have people participate. I think we do want community groups to participate, but they don't really know where to start. So I think that's something that we certainly see an emphasis on. Your first question, how does a police officer determine if a young person is eligible or ineligible to participate in one of those programs? I have a handout that I brought, which I'll make sure that I have available for people to grab, which has kind of a flow chart of how the decision-making process is done. There's a bit of subjectivity that's involved, but most often it's looking at, is this a case where they think that restorative justice or alternative measures might be effective? And if that's true, then how can we make sure that they start building out a program that works and makes sense? So it is a bit subjective, but I'll make sure that I have the document that shows kind of the decision tree and how those decisions are made about whether a young person can get that access or not. Thank you very much. And I think you had the final question because you've got the microphone.
Well, I had a question, but he asked it already. So your second question was my question. So I think I'm covered. So if anybody wants to take my spot, all right. Just one more, and then we're good.
Thank you very much for the opportunity. My name is Justin Dimitri. By the way, if we were to introduce yourself as a lawyer, most of us would have believed it. You did an excellent job.
Oh, thank you.
Yeah. The question I have is regarding, the youth who got incarcerated and went into, juvenile centers. There are some jobs, especially the government jobs and all that. Whenever you're applying, you have to go through, a criminal record check. So with somebody who's a victim of that, is it like a forgetting kind of a thing with those kind of jobs?
Oh, that's a really excellent question. And I think, did you have a second question, or was that
yes,
the... Okay.
I do have the second question. The second question is regarding the committee. Like, how many male and female, like their gender balance, or how does it work?
Excellent question. So for the youth justice committees, they try very hard to have it gender balanced. Because it's volunteer based, it's not like a perfect match of men and women. I would say that there are often slightly more women on the committees, but they would very much like to have it gender balanced men and women. And in terms of ethnocultural diversity, they really want to have the cultural diversity, but most often they haven't been very successful with that. In terms of the question about criminal record checks, so this is a really important distinction about the Youth Criminal Justice Act. If a young person is found guilty of a crime under the Youth Justice Act, so they're, let's say, 15 years old, even if they spend some time in a detention facility for young people, those records are sealed because they're not an adult. So because they haven't been charged as an adult, let's say they were incarcerated for a year at the age of 15, 16 they leave, they have no criminal offenses further, and when they're 21 they'd like to apply for a government job, that criminal record check would not show that they had experienced that juvenile incarceration because it was under the Youth Justice Act. If someone is charged as an adult, so if they have a very, very serious crime, even if they're under 18, that would end up on their lifetime record, most often for serious violent crimes. But even in cases where someone does have a criminal record, one of the things that's done in restorative justice can often be clearing those records or creating like formal pardons for those records so that potentially people, even if they were charged as an adult and they've served their sentence, they can have that eliminated from their personal record so that it doesn't affect them in, for example, getting housing or getting jobs. And so that's one of the kind of like longer term things that's done in restorative justice, but it's also an opportunity that exists and something that obviously can be highly effective in helping people rebuild their lives after they've been incarcerated. So thank you very much. Thank you all for your questions, such good questions.
Thank you so much, Lisa, for all that information. That's really, really great. I think we got a lot from you. And I think this is going to benefit our community, and I really, really appreciate you being here and talking to us about this. Thank you, you guys.
Thank you very much. And I'll make sure that the presentation is emailed so that it'll be circulated, that people can read it afterwards, or that they can circulate it beyond. Thank you very much for having me. I really appreciate it.
Hello, hi everyone. My name is Stella, and on behalf of the Secretary General of ESSCA Canada, I'm the Vice Secretary. Since today's conference is wrapping up with the election, anyone who haven't registered or paid his or annual membership fee should do so and can meet our Finance Secretary Bako so he can register you. One-time registration fee is $20, and annual membership fee is $5 a month, which is $60 a year. Unfortunately, I don't have a registration fee here with me, but your name will be added into the membership registration list for future references. Thanks and regards. Enjoy the rest of the day, and